Hey folks, Alex Gertsburg here, one of the managing partners at Gertsburg, Licata and CEO of CoverMySix. So a few weeks ago, if you watched one of my earlier videos, you learned that there are only 6 plaintiffs who can sue a business: customers, vendors, employees, shareholders, the government, competitors. Only 6, no 7th plaintiff. One of those is customers, and the best way to protect yourself from your customers is with a really good contract. So we're going to talk about that briefly here. 5,000 foot overview of customer contracts. Here's how I feel about them. Most of your customers will sign the contract that you put in front of them. A few of them won't. Let's worry about the ones that will, at least for purposes of this chat we're about to have. Second, when I draft a contract for my clients, I get pretty greedy about it. I often compare it to being that kid in the sandbox that won't let anyone play with their toys, right? I want to get as much real estate, I want to get as much protection for my client into those contracts as I can, because number one, I know that the next time anyone's looking at it is going to be when they want to sue me. And number two, I know that their lawyer is going to be looking at it, right? So I try to bake into that customer agreement as much protection as I can for the company, for the seller of the services, the provider, because they can always walk any of it back, right? They can always say, now I want to give them a little more. That's their choice. But start from massively protecting the the company, our client, the seller, the provider of the services. Okay, what does that mean, right? So divide the contract into 2 sections: business terms, legal terms. The business terms, you want to just get really specific. Here's what I'm selling to you. Here's what I'm selling it to you for. Here's how I'm going to deliver it to you, right? Those are the business terms. Usually those can go into an order form, and then there's a separate master services agreement that provides all of the legal terms. You can put that into a click-through like you do on Amazon when you buy something, or you could put it into a written document. You could put it into an order form. It really doesn't matter. But there should be some written document, whether electronic or paper, that outlines the terms and conditions that you're providing your widget to the world. All right. Business terms, legal terms, right? This is where I get greedy. My company is selling to you, the customer, our product with no with no warranties, right? I'm disclaiming all warranties, express warranties, implied warranties, everything that I can disclaim, I'm disclaiming. You're buying my product as is, where is, without any warranty whatsoever, okay? Number 2, I'm limiting my liability to you. The most that you can ever claim from me is the value of the product that you're buying, really the purchase price. You buy something from me for $500, you can't sue me for $1,000, right? To the extent that that is an enforceable agreement, and your lawyer will tell you whether it is or isn't, you need that in there. You don't want to get sued for a small product for 30 million times more than its value, right? That'll put you out of business, right? So limitations of liability. You also want to limit the kinds of liability that they can bring against you, right? It's got to be for compensatory damages only. No punitive damages, no class action kinds of damages, no special damages, treble damages, compensatory damages only, right? No proximate, distant, or I should say non-proximate, distant consequential damages. Those are not allowed, right? Next, selection of remedies, right? If you have a problem with me, right, your remedy is to return the widget, right? Or I will repair it, or I will replace it. That's your remedy. Put that in the contract. I'm also going to have dispute resolution provisions in there. We just did a video about that a week or 2 ago, so check that out. 5-step waterfall dispute resolution provision that needs to go into every contract. In that same general area of your contract, you're going to have a forum selection clause. If your client is going to, or a customer is going to bring a claim against you, you want it to be where you are, not where they are, right? If all of your business operations are in Cleveland, Ohio, Cleveland, Ohio is where that dispute is going to get resolved. It's not going to be in Alaska because your customer lives in Alaska, right? So that's a forum selection clause, also called a venue provision. Separate but related to that is also a jurisdictional provision, which says which courts will have jurisdiction over your claims. Those all kind of go into this cluster of dispute resolution pieces of the contract. You want to consider whether there's going to be an attorney fee provision in there. If I have to sue you, the customer, to collect money that you owe me attorney's fees, right? Now that could cut both ways, and a one-way attorney provision might be unenforceable, especially as to an individual customer rather than a business customer. So that's something you want to talk to your lawyer about. And then lastly, how can this contract be amended? The answer is it can't be amended unless I, the business, sign a piece of paper says I'm amending it. There's also something in there called an integration clause that goes with that, which basically says this contract is the entire agreement we have. Just because one of my salespeople says something to you separately over a drink, that does not amend this contract, right? So that's called an integration clause. Okay, those are your basic protections that go into a contract for you to have a conversation with your lawyer about. If you've had a conversation with your lawyer about it and those things are not in there, find another lawyer. If they are in there, but you drafted them yourselves or borrowed them from someone on Google, have a lawyer review them. Disclaimers of warranties, limitation of liability, selection of remedies, dispute resolution, forum selection and jurisdiction, attorney's fees, amendments. Thank you.